What if everything you spent the last 30 years planning, your pension, your savings, the state you chose to retire in, every financial decision you carefully built your future around, could be quietly undone by a state legislature looking to balance its budget? What if the rules could simply be rewritten after you had already spent decades living by them? That question just received a definitive answer from the highest court in the United States. And the answer, delivered unanimously by every single justice, is no. They cannot do that to you anymore. I'm Zayne, and welcome to Senior Security Updates, where we cover the legal and financial developments that directly affect your retirement security in clear and practical language. Today, we are breaking down a Supreme Court ruling that most Americans will never hear about, at least not until it is far too late to take advantage of it. Whether you are decades away from retirement or already living on a fixed income, this decision reaches directly into your financial future and reshapes it in ways that genuinely matter. Stay with me through this entire video, because by the end, you will have not only a clear understanding of what changed, but a concrete action plan to use this ruling as a real financial shield. Let's get into it. What just happened? A 9-0 ruling that changes everything. Let's start with the what, because the nature of this decision makes it exceptionally powerful. This was not a narrow, divided ruling. This was not a contentious 5-4 split where justices on opposite ends of the ideological spectrum were arguing sharply with one another. This was a 9-0 unanimous decision. Every single justice, regardless of who appointed them or what legal philosophy they hold, arrived at exactly the same conclusion. In the legal world, that kind of unanimity carries enormous weight. It establishes binding precedent nationwide. It creates a new constitutional standard that every state in the country is now required to follow. It signals to lower courts, state legislatures, and government agencies that this principle is not up for debate. It is settled law. And the principle at the center of this ruling is one that will immediately make sense to anyone who has spent years carefully planning their retirement. The core legal concept: fundamental reliance interests. The court built this entire decision around a concept they called fundamental reliance interests. That phrase sounds like dense legal terminology, but the idea behind it is genuinely simple. And once you understand it, you will recognize immediately why it matters so much for your financial future. Here is what it means in plain language. When you make significant long-term financial decisions, how much to save each year, where to retire, when to stop working, which state to live in, you base those decisions on laws and rules that currently exist, the pension formula your employer offered, the tax treatment your state applies to retirement income, the 401k contribution, rules you have been working within for decades. These are not abstract policy details. They are the foundation of decisions that shape your entire life. When you make those decisions in reliance on existing laws, you create what the court calls a reliance interest. And what the Supreme Court has now said, unanimously, is that governments carry a constitutional obligation to respect those reliance interests. They cannot simply rewrite the rules after you have already spent years or decades living by them, contributing based on them, and structuring your entire financial future around them. Think of it as an unspoken agreement. You held up your end, saving consistently, contributing to a pension system, planning carefully based on the laws as written. This ruling says the state must honor its end of that agreement as well. How the balance of power has fundamentally shifted. To appreciate how significant this is, you need to understand what the landscape looked like before this ruling, and how dramatically it has changed. Before this decision, states had remarkably wide latitude to adjust retirement-related policies whenever budget pressures arose. Legislatures could modify pension formulas, change how retirement income was taxed, raise retirement ages, or reduce cost of living adjustments. If you disagreed with those changes and wanted to challenge them, the burden was entirely on you. You had to hire an attorney, navigate a complex legal system, and try to prove that the government had acted improperly. An expensive, time-consuming, and often unsuccessful process. For most ordinary retirees and workers, the practical reality was that once a state decided to change the rules, there was very little you could realistically do about it. This ruling completely flips that dynamic. Now, when a state wants to change retirement laws in a way that affects people who built their financial plans around those rules, the state must justify that change under a strict constitutional standard. The presumption starts in your favor. The burden of proof sits with the government, not with you. Instead of retirees scrambling to prove they were harmed, state governments now have to demonstrate that their actions are constitutionally justified, despite the harm they caused to people who relied on earlier rules. That is a fundamental and historic rebalancing of power, from the government toward the individual. Who benefits most? 4 groups that gain real protection. While this ruling applies across the entire country, its impact will be felt most powerfully by 4 specific groups. Here at Senior Security Updates, we want to be specific about who stands to gain the most meaningful protection under this new framework. State and local government employees. Teachers, firefighters, police officers, city workers, public health employees. Millions of Americans who chose careers in public service, often accepting lower salaries in exchange for a defined pension promise. For years, states facing budget shortfalls treated pension obligations as a convenient place to make cuts. They adjusted cost of living increases, altered benefit formulas, and raised retirement ages, sometimes for employees who were already deep into their careers and had made irreversible life decisions based on the original terms. What this ruling signals is that if you were hired under a specific pension formula, have been contributing to that system for years, and structured your career expectations around those promised benefits, the state now faces significant constitutional barriers before unilaterally reducing what you were promised. Your years of service were based on the original deal. The court is now saying that deal must be honored. Retirees who relocated. Based on state tax policies. Every year, significant numbers of Americans make one of the biggest decisions of their lives, selling their homes, leaving their communities, and relocating to a different state specifically because of favorable retirement tax treatment. Some states do not tax pension income. Others provide exemptions for Social Security benefits or retirement account distributions. These are not minor details. They are often the primary driver of a major, permanent life decision. Picture this scenario. You spend years researching states. You find one that specifically advertises it does not tax pension income. You sell your home, pack up your life, establish residency there, and build your entire retirement budget around that tax advantage. Then, several years later, the state legislature, facing a budget gap, decides to impose a new tax on pension income. Before this ruling, your options were limited. Now you have a powerful constitutional argument that the state is violating your Reliance interests. You made a major, irreversible financial and lifestyle decision based on their laws. The court is saying that matters. Workers currently building retirement savings. Millions of Americans saving through 401k, 403b, and similar accounts are also affected, particularly when state policies govern how retirement income is treated upon distribution. If a state were to dramatically change how that income is taxed after people had spent decades contributing under a specific set of expectations, the new legal framework becomes directly relevant to their situation. Social Security recipients in states that tax benefits. Approximately 13 states currently apply taxes to Social Security income. For retirees living in those states, even modest policy adjustments can meaningfully affect monthly budgets. If a state were to expand or introduce new taxes on Social Security benefits in ways that materially harm retirees who structured their finances around previous rules, the reasoning in this decision provides a meaningful new avenue for challenging those changes. The 3-part test: how courts will now evaluate state actions. The Supreme Court did not simply announce a principle and leave it undefined. The justices created a specific legal mechanism, what analysts are calling a reliance impact analysis, that courts will use to evaluate any future case where a state changes retirement laws after people have already relied on them. This framework asks 3 questions in sequence. First, did people actually rely on the existing law when making long-term financial decisions? For most retirement situations, this answer is straightforward. Workers decide how much to save, when they can afford to retire, and where to live based heavily on the rules in place at the time. Someone who contributed to a pension system for 25 years under a specific formula is clearly relying on that structure. A retiree who relocated based on specific tax policies is clearly relying on those policies. Demonstrating reliance establishes the foundation of the legal argument. Second, does the new policy cause material financial harm to people who relied on the previous law? Minor administrative adjustments may not meet this standard, but when a policy meaningfully reduces pension benefits, imposes unexpected taxes on retirement income, or significantly diminishes someone's expected monthly income, the harm becomes considerably easier to establish. When both reliance and material harm are present, the burden begins shifting in a powerful way. Third, does the state have a reason compelling enough to justify that harm despite its impact on individuals? This is where the real transformation lies. Before this ruling, states could often cite budget pressure as a sufficient justification for making changes. That may no longer be adequate. A simple budget shortfall may not constitute a compelling enough reason to override the constitutional reliance interests of people who planned their entire financial lives around the previous rules. Courts could require substantially stronger justification before allowing those changes to stand. That third question is where the power shift becomes most tangible. The state now has to prove its case, not the other way around. 3 concrete steps to take right. Now, understanding this ruling is valuable, but here at Senior Security Updates, Zayne and the team always want to give you something actionable, not just information to absorb passively. This ruling is a tool. Here is how to use it. Step 1. Document the promises currently being made to you. This is the most important step, and it requires no legal expertise whatsoever. Visit your state's Department of Revenue website right now and locate the pages that explain how retirement income, pensions, and Social Security benefits are taxed in your state. Save those pages as PDF files. Print them out. Take screenshots with timestamps. These documents become your evidence of reliance, your proof of what the law said when you were making your financial decisions. Apply the same approach to your pension enrollment materials, your 401k plan summaries, your periodic account statements, and any official correspondence from pension administrators or plan providers. Every one of these documents is now a piece of constitutionally relevant evidence that demonstrates the expectations you relied upon when building your retirement plan. If you relocated to a different state based on its retirement tax policies, keep records of that decision as well. Real estate transactions, financial planning correspondence, any written materials you reviewed when making that choice. When courts evaluate reliance interests, the broader context of your decisions matters alongside the specific rules you relied on. Step 2. Consult a qualified professional. Retirement law intersects with financial planning, tax strategy, and estate planning in ways that can become complex quickly. Speaking with a qualified financial planner or attorney can help you translate this ruling into practical guidance specific to your situation, identifying which parts of your retirement strategy depend most heavily on current state policies, what records are most important to preserve, and how to structure your planning so that your reliance on existing laws is clearly and consistently documented. This is general educational information. Please consult a qualified financial or legal professional for guidance specific to your personal situation. Step 3. Review your plan. Documents for changes that may now be unconstitutional. For public employees in particular, this step deserves careful attention. Review your pension enrollment materials, benefit formulas, and any official plan documents that were in place when you joined the system. If those terms were ever changed in a way that meaningfully reduced your expected benefits, documentation showing what existed before the change could become highly relevant under this new legal framework. How states are likely to respond, and what to watch for. This ruling does not close the conversation. In many respects, it begins a new and more active phase. State governments that have relied on their ability to adjust retirement policies to manage budgets are now working with their legal teams to understand what they can and cannot do going forward. Several strategies are already being discussed in policy and legal circles. Grandfather clauses are one common approach. Under this model, existing workers and retirees continue under the original rules while employees hired after a certain date fall under a revised structure. This attempts to reduce future obligations without disrupting the reliance interests of people already in the system, though courts will still need to evaluate whether specific implementations are constitutionally sound. Gradual phase-in strategies represent another approach. Rather than implementing a sudden change, a state introduces adjustments slowly over many years, hoping that a longer timeline reduces demonstrable financial harm and improves the policy's prospects under legal scrutiny. Some states may simply pass aggressive reforms and allow litigation to define where the constitutional boundary lies, effectively using court challenges as a testing mechanism for the exact limits of this ruling. Because the ruling is relatively new, the precise scope of these protections will continue to be defined through future cases. That means the legal landscape around retirement planning will keep evolving, which brings us to why staying informed has become an active part of sound retirement strategy, not just a passive interest. Why vigilance is now part of your retirement plan. In the wake of this ruling, knowledge is not simply power in an abstract sense, it is money. It is your money. Understanding what your state legislature is currently debating, knowing which proposals are moving through committee, and recognizing when a proposed change could affect the financial promises you have relied upon, these are now meaningful components of protecting your retirement. A single policy proposal that seems like a minor technical adjustment could influence your retirement income for years or even decades. When you stay informed, you are positioned to respond early, to seek professional guidance before changes take effect rather than after, and to make decisions based on accurate information rather than discovering too late that your financial plans have been altered by a policy you never saw coming. Closing thoughts from Zayne at Senior Security Updates. For decades, you treated your retirement plan as a personal promise, a commitment made to yourself and your family through years of careful saving, disciplined planning, and deferred gratification. The Supreme Court has now affirmed that your state must treat it as a promise as well. They entered into an agreement when they established the laws you planned your life around. This ruling says they have to honor it. The real question going forward is whether your state understands that it is now constitutionally required to keep that promise, and whether you are positioned to hold them to it if they try to walk away from it. Here at Senior Security Updates, Zayne and the team will continue tracking how states respond to this ruling as new developments emerge. Make sure you are subscribed so you do not miss those updates as this legal landscape continues to evolve. Share this video with someone in your life who is approaching retirement or already depending on a pension, because far too many people are completely unaware that this protection now exists. Simply getting this information to someone who needs it could make a meaningful difference in how they plan and protect their financial future. And drop a comment below. Tell the Senior Security Updates team your state and what your biggest retirement concern is right now. Those comments genuinely shape what Zayne and the team cover next, because this channel exists to address what matters most to you. This video is intended for general informational and educational purposes only. It does not constitute financial, legal, or tax advice. Please consult a qualified professional for guidance specific to your personal situation, and always verify information through official sources. Thank you for taking your financial future seriously enough to stay informed, stay protected, stay empowered, and we will see you in the next one, right here on Senior Security Updates.